Hi, and welcome to today's Chamber Live. Today we're looking at property in a pandemic with Adam Bromley, Jennifer Ross and Laura Hallett Lea from Forbes. The views expressed in this seminar don't necessarily represent the views of the East Lancs Chamber of Commerce, but all facts were believed to be correct at the time of recording, which is the 24th of June 2020. Time to meet our guest speakers. First up, we've got Adam Bromley. He's a partner at Forbes, head of commercial property there as well. He deals with all areas of commercial property, including sales, purchases and leases for both landlords and tenants. He's also got a particular specialism in dealing with pension work, acting for pension scheme administrators and individual clients, assisting with anything related to SIP and SSAS transactions. Maybe he'll explain what that means because I have no idea. Jennifer Ross is an associate in Forbes' residential property department, dealing with all aspects of residential conveyancing, including some very complex transactions. And Laura Hallett Lea is a senior associate in Forbes' dispute resolution department. She's got 10 years experience in property litigation and real estate disputes, and she leads on that area for the firm, advising clients on anything from lease renewals to delapse and boundary disputes. Laura and the rest of the property litigation team work with commercial landlords and tenants, developers, landowners, buy-to-let owners and agents. So that's our team of experts. Time to find out about property in a pandemic. Over to you, Adam.
Thank you very much, Simon. Good morning to everybody. Thank you very much for joining us. It's a beautiful day out there, so I know there's a number of things people could be doing instead, so thank you very much for joining. SSAS is SAS, just for your knowledge, Simon. We've got Taj on the call there, and as I say, that's right up his street as well, one of the administrators we work closely with. This isn't going to be a pension related conversation, but it may stray into some of the realms of those things, and obviously Taj might want to touch on some of those specifics, but it's going to be more of a general chat. But as we say, it's going to be looking at the practical and legal difficulties of the property market in a pandemic, which we've been in for a number of months. And Simon's already done the intros, so not much else to add over and above what's up there on the first slide that Simon's kindly put up. So you'll hear from me to start with, and then later we'll hear from Jennifer and Laura. We're going to do a bit of a brief recap on what's happened over the last few months, because we've obviously gone into lockdown and then coming out of lockdown, and who knows if we'll go into lockdown again, but we'll try and cover all bases and cover all the relevant points off, aiming to be done no later than about 25 past 11. So we've got some time for questions at the end, but as Simon said, it's a fairly small group, so any interaction is welcome. Jump on the chat box, unmute yourselves. We want to keep it as informal as possible, so we've got some points to cover, but happy to have a chat around any topics. Simon, you can just stick the next slide on, please. That's just a quick running order. So as I say, I'm going to start off just talking about some practical issues affecting commercial and residential, just a general overview over a couple of points. I'm going to then hand over to Jennifer. She'll give an update on the government guidance on moving house and some more practical issues, specifically focusing on the residential market, which Jennifer specialises in. Then that'll cover the kind of commercial and residential non-contentious areas of the talk. I'll come back on briefly just to introduce Laura and just to get ready for the litigation aspects of the chat. Property law doesn't change very often. It's usually a fairly stoic and slow moving area of law, but in the last few months it's been quite the opposite. So we've had a lot of exciting things to talk about and update, and so Laura can update us on the ever-changing legislation at the moment, extensions to moratoriums and all sorts of interesting litigation related topics. And that, as I say, Laura will hopefully get on for about no later than about 10 past 11 and take us through to the end, and then we've got questions at the end. So that's the order. Simon, you can just put the next slide on. I'll start off, as I say, practical issues in the commercial sector. So the next slide will be about practical issues in residential. Some of them do mix in together, and Jen will touch on some specific points in more detail. But I think that the first thing to say is that there's obviously been massive uncertainty in the market. That's the first thing that happened. and there was a lot of uncertainty surrounding values. We were just having, before everybody came on the call, we were just having a chat, and that's the first thing people talk about is the value of property going to be affected due to COVID. It came out of nowhere, and all of a sudden there was the uncertainty when things were very buoyant and going along very nicely in the market. Value can be affected in relation to the actual property value, the market value, and also rental values. At the moment, the word is uncertain. We don't know yet, and it is causing issues in that it's causing delays to transactions, and it's causing people to be a little bit reticent about whether they proceed with certain transactions. So we're waiting to see what happens. At the moment, values are holding up, but especially in residential, which I'll come on to. In commercial, different sectors are different, and I'll come on to that. There's been practical issues in people getting surveys and valuations done. That was one of the biggest issues, that it was a case of when lockdown was imposed, people just couldn't access properties. So whilst we had clients and we had people who wanted to get on with transactions, they were prevented from doing so. They couldn't get the surveys done. The surveyors weren't able to go in and do that and get the access. And in relation to valuations, as I say, there's uncertainty over that, and valuers have been very cautious about what they do. There's been some information sent out by RICS in relation to valuations, and they did indicate that valuations could be made subject to what's called a material valuation uncertainty clause. So most professional bodies have moved to try and deal with the situations, and it has been kind of identified that different sectors and different markets are going to react differently to the pandemic. So valuers were given that opportunity to be able to insert a clause that says, look, this valuation has been done in very strange and unprecedented times. We really are unable to confirm what impact it will have on value, and able to cover themselves and able to then get those valuations done with that caveat. Obviously, people then have to decide whether or not they're prepared to proceed with that sort of caveat in a valuation, and that can be different depending on whether it's an individual relying on it, as I mentioned about pension work, whether it's a pension fund relying on it that have stricter HMRC guidance to look at in connected transactions, or whether it's a lender looking to rely on a valuation. So depending on who is relying on the valuation causes practical issues. So we're still seeing uncertainty surrounding that even as we come out of lockdown, but we are seeing different sectors being affected in different ways. I think at the moment, whenever we turn on the TV, if we're not looking at what the quarantine rules are going to be for travel, which Simon has already said to us he's interested in looking at, then we're looking at when are the pubs going to open. I think that's the other important thing. And the leisure industry, as I say, has been affected massively, and has been at a complete standstill, and we're just waiting to see what happens as that starts to open up again. Other sectors haven't been as affected, manufacturing, construction, these sorts of sectors that lockdown rules were kind of relaxed a bit earlier on, coming into offices subject to complying with social distancing. Key workers has been permitted. So different sectors have been affected differently, and we're just still obviously working through it, and that causes its own issues. It'll be interesting to see as we do start to relax the rules whether or not we have the second wave, and whether we need to go back into lockdown. But I think it'll look very differently if we did need to, because as I say, people have reacted very quickly in this last 3 months to the relevant challenges, and I think we'd go back into lockdown in a very different way. Other issues, just practically, as I say, law firms, other professional services companies, not everybody has been able to carry on working in the same way. I think Jen would agree, she may mention it later, that say certain firms just shut down, certain firms made decisions not to proceed with transactions. So there's been a whole range of reactions to the pandemic, and as I say, it's always the case with any sort of conveyancing transaction that you're only in control of certain parts of that transaction, and there's a chain of people involved. So delays sometimes do kick in because other solicitors just aren't open, aren't in the offices. A number of law firms, especially in the property sectors, furloughed a number of staff and still have staff on furlough. or reduced capacities to do the work, and that's caused delays, and that causes issues in relation to the clients, and the land registry have also had reduced working requirements. I think in commercial, it's not been as badly affected. It's not as kind of fast moving as residential is, and not as emotional. If Simon, if you can just stick the next slide on, I'll just kind of move on to the residential side, because the commercial side is, I would just mention, is kind of people had some transactions, they were still able to do them a bit more. It wasn't as key in relation to moving house, it's not as emotive. So those transactions, people were able to just sit back, take a bit longer, and it's only now that we're starting to see that urgency creeping back in and people wanting the transactions to happen. In residential, it's been fairly hectic from day one. We expected to see a massive slowdown. Right at the outset, there's the initial guidance, lockdown, obviously 23rd of March, we were put into lockdown. As it often happens, there wasn't any specific guidance in what to do, and that first week of lockdown, which seems a long time ago now, was a strange time. I remember speaking with Jennifer at the time and looking, well, what do we do? We've had this lockdown, people have got transactions that they've exchanged contracts on. What is the guidance? What do we do? And it was very uncertain. So it was a different kind of reactions in different firms, different clients at different stages, and we worked through that initially. And then it was towards the end of that first week, end of March, some guidance started to be issued that really kind of put a hold on the residential market in not allowing people to move house due to all the relevant restrictions. So then we've had, as I say, we've had a number of issues then during lockdown in relation to just managing those transactions, keeping the transactions going, managing clients' expectations when they wanted to move but maybe couldn't, differences between properties being vacant, properties being occupied, just working through it without any specific guidance and just kind of taking each case on a case-by-case basis. Lockdown, 13th of May, was when the housing market kind of reopened, the lifting of lockdown, and did normality resume? Well, again, the guidance was unclear, but the challenges that have been faced for ourselves have been that once people are told you can move again, the phones are ringing off the hook. People are wanting to do that, they've got the transactions on hold, and obviously the lifting of lockdown has been subject to some very strict requirements in any event. So it's just been working through that. The levels of demand, as I say, without giving specific numbers, I would say that in March, April and May, our kind of usual file opening type numbers, usual transactions we were dealing with, were probably cut to about a quarter or a third, really heavily cut down in relation to people carrying out new transactions. This month, we will see higher numbers than we saw in June last year. We've got higher numbers already. We've got a week to go in June, and we've got something like 40 quotes out, and we're converting at the moment at about a 90% rate of those quotes that are coming in. And that just gives a real flavour of just that pent-up demand that's been there. So we're now in absolutely crazy levels of demand, and people wanting to move and buy the houses, and values at the moment don't really seem to be being affected. What does the future hold? That's going to be the real key, and that is kind of trying to predict what happens. I think there's a lot of new challenges to come. I think at the moment there's pent-up demand. People have been sat there doing nothing for 3 months. They want to move house. They want to make these things happen. They want to change the scenery. I think people have got a lot of cash stored up. They haven't been spending on the usual things they spend on. They've not been spending on the holiday they'd normally have a chunk of money put aside for. So I think people have got deposits that they're ready to use. So I think it's a very strange time at the moment. And obviously the furlough scheme is still in full effect. We aren't seeing waves of redundancies. We aren't really seeing businesses impacted in that way the same. I don't want to be too kind of doom and gloom, but start fast forwarding in a few months when furlough starts to gradually reduce and come to an end. Businesses really start to feel that the impacts of COVID in the months to come, Redundancies will no doubt start to happen. We're already seeing noises in the local market about that. So I think that will face a challenge in the future. And then we'll have to wait and see what impact that has and whether that does start to impact on the number of transactions, the number of mortgages, and whether it impacts on value as well. So we're waiting to see what happens, but at the moment it's very, very buoyant in the property market would be the kind of opinion that we would give and the feedback in relation to what's happening on the ground. Simon, if you can just do the next slide for me, please, just to move on from those kind of general practical issues, just to quickly talk about some legal issues. If you can just stick up the first poll question up for me, please, Simon, before I forget. I could just ask everybody to just have a look at this question, and they could answer this for me just to see what the general feeling is from people. Is, can an electronic signature be used as a valid way to sign a contract? Okay, so big 71% yes, 29% no. Before I just comment on those results, I'm just going to ask a secondary question. If you can just put that up for me as well, please, Simon. And sometimes when you get a second question, it often starts to make you think about what the answer to the first question was, and whether that impacts on the answer to the second question. So, but just with an open mind, so the second question is, can an electronic signature be used as a valid way to sign a deed? Okay, so yeah, this switch the other way, slightly more of a percentage of no than yes, but similar numbers surrounding that. I think some people have probably slightly changed the answer and got the gist. So it's just to firstly mention really that general legal position is that electronic signatures are permitted, and most normal contracts can be executed by way of an electronic signature. So the answer is yes, you can execute a contract, you can sign a contract by way of an electronic signature. That's been something that's been looked at and has been a hot topic way before COVID was ever anything that we knew about. It was something that the Law Commission published a report on in September last year, looking at that, and we're already starting to identify the movement towards electronic signatures and the modernisation of some of the conveyancing practices in general, and other areas of law that require signatures of documents. And I know from, as I say, I've mentioned Tadji's on the call, I know Jonathan's on the call. Unfortunately, I don't know what the other people do who are on the call, but if people want to kind of let us know what people do, that will be really helpful. Different businesses are using electronic signatures to execute and sign documents, and it's important. Unfortunately, deeds cannot be executed by way of an electronic signature. The land registry requirements are still extremely strict. They require a wet ink signature, and it needs to be physically witnessed. So video witnessing isn't possible either. So remote witnessing isn't possible for deeds and anything that needs registering at the land registry. So that's kind of, I think, a reflection of the importance of the value of a property, making sure that fraud isn't being committed, and making sure that those requirements are in place. So that there is a big push, and the land registry have brought in some relaxed requirements to allow a form of electronic signatures or remote signatures called the Mercury process, which involves somebody being able to just print off the document. They still need to sign it, they still need to have it physically witnessed, but they can scan those documents back in, and the final signature page can be attached to the document. So there are some measures being brought in to speed things up and to acknowledge what's happening at the moment, but it isn't replacing the need for those physical witnessing and physical signatures in anything that needs to be registered, and that is still causing problems. And when I speak to colleagues who work in other areas of law, they do see the property side as being a bit archaic, a bit old-fashioned, but we have our hands tied until the land registry feel comfortable in relaxing those requirements. So yeah, at the moment, as I say, the electronic signatures are coming in. It is being revamped. It is becoming more and more common for certain documents, but unfortunately, for anything that needs to be registered, we're still stuck with letting signatures. Simon, we can just move on to the next slide, which is the last point I just want to talk about before I hand over to Jen. Delay clauses in contracts. This is just to really say that this is something that came out fairly quickly in relation to transactions right at the outset of lockdown. First of all, to deal with contracts that had already been entered into, that had already been exchanged, that people were concerned about risks of not being able to complete on time due to COVID. Again, we were chatting before we came on to the webinar, and people were giving examples of people needing to vacate properties but not being able to do so due to the restrictions. So there were lots of delays and lots of practical issues being created due to COVID that wasn't any fault of anybody, and they were subject to contracts that they needed to perform, and there were no provisions for them not to perform those, and could have been subject to compensation payments and losses of deposits if they didn't perform them. But being conscious of the delays not being anybody's fault. So what we've seen since then now is that contracts that have been negotiated, Jen will talk about exchange and what can be done to mitigate those kind of risks. But if there's going to be an exchange with a completion date at any point in the future, then these sorts of clauses, as I say, are being heavily used, heavily negotiated, and we're doing a lot of those, implementing these clauses to achieve situations where a coronavirus event can be defined as any event really that happens that's going to cause a delay due to COVID. So then the clauses in the contracts can factor in extended completion dates, or they can factor in what happens at that point in relation to the parties and what their provisions are under the contract, whether they can bring the contract to an end, or whether it simply allows a completion date to be extended without any kind of financial penalties. So that's what's being used. The clauses are there to be legal, to be binding, to bind the parties. We're still encouraging people to kind of take a reasonable view and to kind of collaborate together. And there is, as in a lot of legal documents, there's an obligation to mitigate and make sure that you're doing all you can to enable the contract to be performed and to be completed on time. But as I say, these clauses now are being used as just a bit of a formal way of saying, look, these events could happen. We could enter into this contract, things could change outside of our control, and completion may be delayed, just so that people aren't penalised. So that's something that we're seeing a lot of now, and people and the clients that we're dealing with are very aware of it and are proactively asking for those clauses. So that's been something that, whilst it's been an issue, it's made us find a way to get around those problems. So that's kind of everything I wanted to touch on in relation to some of the practical and legal implications on a wider basis. I'll hand over to Jennifer now. Simon, if you can just put the next slide up. That's Jen's first slide. I'll hand over to Jen and she can take you through the residential specific issues that she would like to talk about.
Hi everyone. So I've been asked to speak today with regards to practical issues in setting up completions and in particular determining challenges that we're facing with regards to exchange and completion. The government guidance is now that sales and purchases can take place, so people are able to move, and house viewings are also now taking place. I wanted to start off with a question, the poll question, just to see if anybody has been impacted by COVID-19 in respect of a house sale or a house purchase. That's quite interesting. 71% said no and 29% said yes. I think, as Adam had said, when the pandemic first came out and we had ongoing transactions, clients were desperate to get contracts exchanged and completed before the lockdown came into place because everyone was uncertain what was going to happen. Once lockdown did come into place, then transactions had to be put on hold. Like Adam said, solicitors' offices closed down. But we have seen now that restrictions are being lifted, that the market is buoyant and people are wanting to move. And as Adam said, we've got a lot of new instructions in Whether that will remain is yet to be determined. From a client's point of view, they want us to exchange contracts as soon as possible, because that then gives them the security that the sale or purchase is going to proceed, and they can obviously put arrangements in place like removals, ordering new furniture, things like that. However, there are now other factors that clients will need to take into consideration as a result of COVID-19. If you could put my first slide on, Simon. So conveyancing transactions are taking longer than normal at the moment. This is due to, as Adam said, we've had solicitors' office closing, estate agents not being able to do viewings, searches that we have to submit was put on hold, and certain searches weren't being carried out. And again, surveys weren't being done, so mortgage offers, that caused a delay in mortgage offers being issued. And if buyers wanted home buyers surveys, then these surveyors couldn't attend to do a physical inspection of the property. Also, parties may not wish to proceed due to uncertainty. Again, a lot of people was put on furlough. People are still on furlough, so they've got worries, job worries. First-time buyers that we deal with, a lot of those do receive gifted deposits from parents. So again, if they're on furlough or have got job insecurities, worried about redundancy, it may be that they're then in a position where they can't provide the gift that they was originally going to give to their child. Other matters that need to be factored in is that, excuse me, that the transaction may have to be put on hold at short notice. For example, if someone in the chain contracts coronavirus, or if the government, if there was a second wave and then the government issued further lockdown provisions. There are other factors to consider which are more out of the client's control. So there's difficulties if a seller's unable to vacate the property because they're in self-isolation. Requesting mortgage monies from lenders. Lenders now require maximum time for us to draw down mortgage funds. So if we're not in a position to give that time scale, we could put the client at risk of not getting the mortgage funds on the actual day of completion. Removal companies may not be able to enter into a property if somebody's self-isolating. So again, the client wouldn't be able to physically move in or out on the day of completion. And also elderly clients who rely on their families to help them move. If family members are in self-isolation, then again, that could have an impact on the completion date. The monies that we receive from the clients, we request through the banking system, and we also request the mortgage advance through the banking system. So again, if there's any disruption to that due to COVID, then it could result in us not receiving the monies on the actual day of completion. I think Adam's touched on this, that we would normally have a face-to-face appointment with our clients to go through, get contracts and certain documents signed. In particular, there's a transfer deed and a mortgage deed that the client has to have. We have to have an original signature to that deed, and it has to be signed in the presence of a witness. At the minute, we've only been carrying out essential appointments with our clients. So clients are having to obtain witnesses whilst adhering to social distance measures. So the standard conditions of sale which are incorporated into a residential contract state that once contracts have been exchanged, that's when the contract becomes legally binding, and that's the date that the seller must be in a position to vacate the property and the buyer in a position to hand over the monies to buy the property. If either party was affected by COVID-19, the contract would still be valid, and if there would be penalties if for some reason the clients couldn't complete on the day of completion. As Adam says, we are agreeing additional clauses for the contract. However, there isn't any law society guidance on suggested clauses, so it is part of the solicitors in the chain agreeing the clauses for the contract. Sometimes they can actually cause a delay in the transaction, because if all the parties don't agree to the clauses, then it wouldn't be fair on the person who they're not agreeing to. We have been recommending to clients that we proceed with a simultaneous exchange and completion, because we feel that that protects both the client and the chain in the event that someone does have to self-isolate or can't move on the day of completion because of COVID-19. A simultaneous exchange and completion means that on the actual day that the client is moving, if the chain is agreeable and everyone is in a position to move on that date, then exchange of contracts and completion takes place at the same time. If contracts have already been exchanged, we can, and completion couldn't take place, we can deal with a deed of variation of the original contract to defer the completion to a new date. However, we would recommend to clients that they take a practical approach on it, with a realistic view to referring dates until such time as the chain would be in a position to proceed. We couldn't expect a client to move into any home where somebody's ill or if they were self-isolating. And that's it from me.
Thanks for that, Jen. That covers off the first part of the presentation surrounding commercial and residential, practical and legal impacts. And that's from the non-contentious side of things, where everybody's all trying to achieve the same aim, achieve the same goal. Laura, who I'm going to go to very shortly, as I say, is our property litigation specialist and lead on that for the firm. And that's Laura gets involved where people have maybe had a bit of a fallout and haven't necessarily agreed on how they want to do things. But I'm sure she'll also touch on points where at the moment people are trying to be collaborative and find a joint way of working through things. So as I mentioned at the outset, there's been a lot of changes to property legislation, lots of extensions of dates and moratoriums in relation to forfeitures and evictions that Laura's going to touch on. I think a big bulk of Laura's presentation is going to touch on leases, both residential and commercial. That is definitely a big area at the moment that is obviously impacting, because whilst people can make informed decisions whether they want to proceed with a property sale or purchase, leases people are subject to. Landlords want to collect the rent and tenants don't want to be paying rent. So leases is a big area that has been concerning us through COVID, and the future of leases and what that might mean for future lease terms being negotiated, that the rise of the use of break rights to end leases early, and new terms that may be negotiated. So I won't steal too much of Laura's thunder. As I say, she's got a fair bit of information to go through, and I think it's going to be very, very interesting because it is subject to lots of legislative changes. So without further ado, I will hand over to Laura to take us through that part of the session.
Thank you, Adam, and thanks. I'm unmuted, yes, so I think you can all hear me. So yeah, there's a lot I'm going to cover today regarding residential landlord and tenant, commercial landlord and tenant, and touching on the issues that we've been dealing with since March, and how that is very different. In the whole, it's very different from what we've been dealing with before that. So I'll start with residential landlord and tenant. So if you could move to the next slide, please, Simon. Thank you. So the biggest news since March is that notice periods in assured short-haul tenancy agreements have been extended. So previously a Section 8 notice would be 2 weeks, it's now 3 months. Section 21 notice would be 2 months, and now it's 3 months. And these are minimum notice periods. So even when you've got a tenant in a lot of arrears, you need to serve a notice immediately because you're not going to be able to do anything about it for 3 months. There's also a stay on residential evictions and enforcement until the 23rd of August. So what that means is you can serve your notices 3 months, and when they expire, you can issue possession proceedings in court in order to get a possession order to kick that tenant out. As soon as you issue that, the court will automatically stay those proceedings. A stay is like a pause, and the court will take no action. They will not list a hearing. They will not expect the defendant to respond to the claim. And that's until at least the 23rd of August. And as you can imagine, the court will be dealing with massive backlog after the 23rd of August or such other period as it's extended. I can't imagine it will be extended beyond then, but stranger things have happened. So the main impact of this for commercial landlords is rent arrears. Sorry, residential landlords, but obviously commercial as well, which I'll come to. So there's been tenants refusing to pay, tenants being unable to pay genuinely, tenants paying partial amounts in the knowledge that the landlord is unlikely to be able to do anything about it. So landlords have been dealing with this differently. On the whole, agreements have been reached between landlord and tenants for reduced rent or perhaps a payment break for a period of time. Others haven't. So landlords have been faced with a situation where they usually serve notice to be safe. Tenants have the option of catching up. So when it comes to August, you may have served a Section 8 notice saying, I want you out by 3 months' time. The tenant then has the option to pay at the last minute. So on the 22nd of August or whenever a hearing date is listed, they can catch up with the arrears, and that will defeat in most cases, that will defeat your Section 8 notice. So we have been advising landlords to serve Section 21 notices. That's the non-fault based notice that you can serve on your tenants, just to make sure that if you still wish to evict that tenant, you can do so. I should also mention that doesn't apply, none of these rules apply to lodgers and trespassers. So if you have somebody at your property who is not a tenant, then ordinarily these rules will not apply. Lodgers generally don't need any notice periods or court action in any event anyway, so that's not much difference. So commercial landlord and tenant, I'll first deal with commercial landlords. So the biggest news ever, probably in 20 years in landlord and tenant legislation, is that there's now a moratorium on forfeiture. So that basically means that until the 30th of September, or such other period is extended again, no landlord can forfeit a commercial premises for rent arrears or any other breach. And that includes any payments. So there may be historic rent arrears, there's nothing you can do. As a landlord, you can't take forfeiture proceedings against a tenant at the moment. It also provides that you also can't waive your right to forfeit. So any action you take up until 30th of September won't waive your right to forfeit in the future. So that's a little bit of good news, because it means that landlords and tenants can come to arrangements between themselves and freely negotiate without the worry that the landlord will lose any of their rights or waive any of their rights to forfeit in September. So I'm being asked a lot at the moment what other enforcement options are available to me. So as a landlord, if you have a tenant in arrears, you can't get them out, what else can you do? So CRA is commercial rent arrears recovery. So that's when you send in the bailiffs to the premises to levy goods in satisfaction of the outstanding amounts. That has to be for pure rent, so not service charge, interest, costs or anything like that. You can only do it for pure rent. The rules have changed recently due to COVID, that rent has to be 90 days of arrears. So it has to be a full quarter's rent outstanding. A tenant can pay 1 day's rent to get it under 90 days, get it into 89 days, and we can't use CRA. Insolvency was open to us and is technically still open to us until next week, we think. So the Corporate Insolvency and Governance Bill should receive a royal assent next week. The courts are already interpreting the rules as if it had already come into place, which is very odd, but we live in very odd times. So the CIGB states that a landlord cannot, it also deals with suppliers as well, but for the purposes of property, a landlord cannot issue statutory demands, bankruptcy proceedings, or a winding up petition against a tenant for rent arrears. So what that means is that exactly what I've just said, is that you can't issue any winding up petitions or issue any statutory demands until this period has ended. The date is the 30th of June at the moment, but obviously with it only being received royal assent probably next week, that's probably going to be extended, I imagine, to the 30th of September. So we can't issue any insolvency proceedings. So there is an exception to that, and that's if the landlord can prove that the arrears are not COVID related. Good luck proving that in today's markets. It would have to be a business that hasn't been affected at all by COVID-19, which I can't think of one that's completely unaffected. Still have the option of issuing court proceedings, and when you do that, that's still absolutely fine and normal. The only difference is the courts are very, very busy at the moment, and it will only get you a judgment, which will give you certain powers, such as sending in bailiffs, which again you've got the same issues with. I'm just going to have a look at this question. Is that all right if I deal with it like that? Oh, sorry. So that's been sent privately, so I'll respond privately to that if that's okay. Okay, so rent concessions. We're dealing a lot with landlords and tenants where they've been asked to reduce rents, increase the rents, sorry, not increase the rent, reduce the rents, increase the period of time to pay, perhaps slash the rent in half for a period of time. And in response to this, the government has produced a code of conduct to how these requests should be dealt with. My landlord clients are dealing with it in very different ways. Some are simply allowing it to keep hold of the tenant. It depends on the negotiating power of the parties. A lot of landlords are taking a zero tolerance approach, especially with the big corporation tenants who've clearly got cash reserves. My advice would be to get the information first before you make a decision. So if a tenant asks for a payment break, asks to not pay rent for 3 months, then we want to know why. Have they actually had to shut? Did they have any cash reserves? Do they have insurance, which I'll talk about in a bit too, rather than just agreeing it. So I'll answer this question now if that's all right. Okay, so it looks like this. So this question is, a commercial client whose lease expired on the 31st of January, and you say my client has made, sorry, this is from Mark, client has maintained payments. So assuming that this is a tenant client who has continued to pay rent, lease expired on the 31st of January. So it's likely that this lease is holding over under the 1954 Act, and that means it will continue until somebody serves notice. So a tenant can serve a 3-month notice, a landlord or to leave, or a landlord or a tenant can serve a notice between 6 and 12 months to ask for a new lease. So there's various options available to that tenant. The landlord would have to serve at least 6 months notice to evict and would have to have grounds to evict. That's assuming it's within the 54 Act. Some leases are excluded, so I would actually have to see the lease to answer that specifically. I hope that answers that, but it's a minimum period of 6 months. I think this is a short answer. Side letters and variations. I'll come on to why this is really important later on as well, because of lease renewals as well and various other things that interact with them. But we would recommend always that a side letter or a variation be entered into if there's going to be a rent concession. And the reason for that is that we need to be very, very clear what is being agreed. A 3-month rent holiday means something different to different people. Will that 3 months be added onto the end? Is it a loan? Is it going to be repaid? What happens to interest? Who covers the costs? When does it kick back in? Is it going to be taken into account on renewal? Is it going to be taken into account on valuation on renewal? Is anybody's insurance cover covering this? There's a lot of things that need to be taken into account, and nobody's going to specifically be able to deal with all them unless you put it in one document. So for commercial tenants, above and beyond what I've discussed in terms of rent concessions, tenants are often asking for rent concessions, obviously because they've been hit by COVID-19 and they're unable to trade or trading much less. Again, there's things that you can put in a side letter that will protect you, as well as the landlord. Keep open covenants. This is something that I'm watching very carefully. It's quite an academic point at the moment. So a keep open covenant is where you would have, as part of your contract, your lease, it would say, for example, as a tenant, you must remain open for trade between 10 and 4 each day as a minimum, or it may say that you have to open every Saturday, especially with shopping centres or concession stands. So that's no longer possible for some tenants because of the legislation and because of the government's rules and because of lockdown. 9 times out of 10, a landlord will be fine with that, obviously, and a tenant won't even bother to have that conversation with the landlord. But any breach of a lease comes a risk of forfeiture down the line, and comes a risk that there may be issues on lease renewal. So if you have a keep open covenant, your landlord's happy with you not to comply with it, just get that waived in writing or by deed. So we'd want something that said, I know you have this obligation, but for this period, I'm not going to enforce that, because you might have a problem with your lease being forfeited in the future for not complying with something that you have no control over. So like I said, 9 out of 10 times that will not be a problem. But I can imagine a lot of tenants getting their leases forfeited in the future through no fault of their own. I was going to just mention on, I'm a bit conscious of time, I was just going to mention on shared spaces, it's interesting who might be responsible for the social distancing rules, whether that be the owner of the property or the individual licensees, which it is normally the licensees. Generally the common parts are the property owners, and the occupiers are responsible for their own space, but that's going to depend on each individual case. So break clauses, this is another interesting area which I'm got my ear to the ground. There's going to be cases on this. There's going to be interesting cases on this. Notice periods for break clauses. This is where a tenant can end the lease early, normally on a 6 to 12 month notice period. Notices have been fine. We've even managed to use process servers during this lockdown. The issue comes with conditions. So as the same would happen with a house move, where you have to give vacant possession at a given time or a given date, with break clauses, it might say you have to give vacant possession on or before the break date, and you must pay all rent, and you must materially comply with all the other conditions of the lease. That might be impossible. That might be completely impossible in a pandemic, even now. And you might have agreed a rent concession. Do you still have to pay, or are you going to frustrate your break? The answer is that if you don't comply, yes, you will frustrate your break and the lease will continue. That is the answer. As it stands, there may be case law. There's a lot of case law on breaks, and the courts have never relaxed any rules on breaks. So I can't imagine they will start doing so now. The answer to deal with this is long before your break date. Obviously, you serve your notice correctly and in accordance with the lease, which is another area I could look at separately. But it's to make sure you agree what level of compliance you are going to do, and then get your landlord to specifically waive compliance with the other terms, or agree what level of compliance is acceptable, and that is by deed. There's no other way of doing that. Or if it's unclear, you have to get to court and get a declaration. So it's about taking the advice and looking at these things very early. Insurance, tenants often have business interruption insurance, and the highlight of this is you're generally not covered. Unfortunately, most don't specifically deal with pandemic insurance. There's a couple of add-ons which tenants have, businesses have, such as notifiable diseases, which COVID-19 is, denial of access, where a government has literally shut you down, for example, in times of prohibition. Denial of access, so that would be, example, you're in a shopping centre and you literally can't get in. Loss of attraction, the best example of that is, say, a hot dog stand in a theme park. Theme park's closed, no one's going to come to your hot dog stand. Landlords sometimes have loss of rent insurance. Again, that's very unlikely to be usable now, because you have a document that says the rent's due. Only because your tenant's not paying. Your insurance company is generally not going to care about that unless the building is burnt down. So that's the long and short of insurance. Insolvency I've touched on, so I won't go into too much detail, but the Corporate Insolvency and Governance Bill does prevent any insolvency action against tenants at the moment. There are exceptions, which is basically, it's not COVID-19 related, and the tenant would be in arrears and unable to pay all its debts as they fall due, whether or not the pandemic had happened and lockdown happened or not. And that's going to be almost impossible to prove, apart from with businesses that have been completely unaffected by COVID-19. And also you're talking about 2 or 3 extra hearings to prove these points. Or without exception, it was better to wait insolvency proceedings and wait and see what happens. Telephone and virtual hearings all I can say on that is that they're absolutely going ahead, absolutely fine, and there's been a review of them. As lawyers, we're encouraging more and more of that for various cost-cutting and environmental reasons. Oh, and we do, electronic signatures are fine and have been in the civil courts for some time. So possession proceedings, as I mentioned before, there's a stay in all possession proceedings, and that's Practice Direction 51Z. The lifting of the stay is exceptional circumstances. We hear this term a lot and more, and it means different things in different situations. My view is that an exceptional circumstance has to relate to the reason why the rule was put in place in the first place. The reason why we aren't allowed to evict tenants at the moment is not just the financial impact of COVID-19. It's because if you have to have a bailiff taking somebody out of their premises and then you have to rehouse them, it involves a lot of social contact, which risks the public health. So that is what exceptional circumstances, I think, means. And there is a case on that which I'm going to come to and ask you to vote upon. So this is the case study it came out last week or the week before. It's a mortgage repossession case. It's a little bit complicated and there's lots of people involved, but briefly, Arkin was the mortgage receiver and Marshall is the debtor. So Marshall owed money to Arkin, and Arkin had a charge which they were seeking to enforce by gaining possession of the property. The directions hearing occurred on the 26th of March, so that's where the court decides the next steps towards trial to making a final decision. It's like an interim hearing. That was on the 26th of March. It was actually the same day Practice Direction 51Z came into force. The directions were agreed, so things like witness statements, who's going to be witnesses, when the trial will be, that was all agreed and should have then followed on to be complied with over the coming months. So what actually happened was that Marshall refused to comply with the directions and said, oh, Practice Direction 51Z, I don't need to do these things. I can just stay in here for as long as I want, and there's nothing you can do until this stay is lifted anyway. So I refuse to comply. So Arkin said, well, actually this bar is unlawful. And there was a lot of discussion about whether the government have the power to deny such access to justice. Article 6 is the right to a fair trial. So an automatic stay is that in breach of a fair trial. Ultra vires literally means against the law, against the power of the law. And even if it isn't, you should still comply with the directions because it's not a possession, it's just a direction. They also tried the exceptional circumstances, being that these directions had been agreed, you had a bargain, you didn't comply. So Marshall simply said, no, there's a bar, and I don't have to comply, and I'm quite happy to stay a bit longer. So this is the poll now on the next page. So who won? Arkin, remember, is the mortgage receiver, Marshall's the debtor. So if Arkin won, got possession or towards possession. If Marshall won, that means the debtor won and they got to stay. So 75% Marshall, and that's correct. So majority was correct. So the tenant was, sorry, not tenant, the debtor was allowed to stay and will be allowed to stay until at least 23rd of August, after which time they will then comply with the directions, and I imagine will be there till probably January, which seems a little unfair, especially since by that point, let's hope we're mainly out of this pandemic. This is the last thing I'm going to talk about. You'll be relieved to know, because I've gone a little bit over, is the impact on lease renewal proceedings, and this also feeds into the question that Mark's asked me. So under the Landlord and Tenant Act 1954, unless a lease is contracted out, a tenant has got a right to ask for a renewal on the same or similar terms at market rent. A landlord can refuse on certain grounds. So those are normally things like redevelopment or the landlord wanting to occupy it themselves. So I suspect there's going to be an increase, and I've already run these arguments, to use what we call ground A, and that's rent arrears. So you can say, I'm not going to give you a new lease because during this lease you didn't pay rent and you put me to expense having to chase you for rents. so I don't want to give you a new lease. That's a nice, easy ground to rely on as a landlord. And it also means that there's no compensation payable if the tenant doesn't then get a new lease. So I imagine that's going to be used more and more, which is another reason why side letters are really important, because that can be covered off by some kind of promise by the landlord not to rely on the rent arrears because they've been waived. I imagine there'll be case law dealing with whether waiving the rent arrears now means you can't rely on it as ground A. I don't know. And that's not something that's ever been publicised before. Even new leases and renewal leases that are being granted, it's going to be extremely difficult to assess the rent or the interim rent period, which is when the notice expires but before a new tenancy is entered into. The same problem with valuations we were discussing before. It's going to be very difficult for an assessor to say what the market rent is and was and will be, given that a lot of shops are closed and may not reopen, I imagine. So yeah, another plug for why you need side letters. So that's it from me, unless anybody's got any questions. And Mark, please get in touch if you want to discuss that further.
I just quickly unmuted myself, I think. So yeah, we're conscious that we're up against the time. If people do have time and want to ask any questions, then please do. Otherwise, there was, I don't know if we can just stick the slides up briefly. There were some contact details on there. I think most of the people on the call we know anyway. As I said, there's contact details. If anybody does want to get in touch outside of this webinar, email us or give us a call. Happy to chat things through and discuss them at more length. I just wanted to say thank you to Laura and Jennifer for the presentations. They were really, really informative, really good. We've got one of our colleagues is hidden away just on this call at the moment, no video. I just wanted to say thank you to Joe Hyam, just to put that on record. Joe's done a lot of work in prepping our slides and materials for today, so a big thanks to Joe for that. I'd just like to thank Simon and Jen for giving us this opportunity today, and thank you to everybody for coming on and participating, and I hope everybody got what they wanted out of the session. So as I say, get in touch if you need anything, and we'll follow up.
Brilliant, thank you Adam, thank you Jennifer, thank you Laura. If anyone wants to put a quick question, since it's such a small group, we're happy to take any. We will also circulate those contact details. Are you happy for me to circulate the PDF of the slides as well?
Please, yeah, if you can do that.
I'll do that in the follow-up email with a link to the YouTube video as well. Any questions for anyone? Just unmute yourself and throw them in. I'll ask a personal one. On the domestic market, sort of from offer being accepted to moving in, what sort of timescale should I be thinking now? Is that extended because of the situation at the moment?
It's just really difficult to give a timescale. That's what most clients are asking us, and because, like you said, there's delay with searches, mortgage offers. You could get someone in the chain who has to self-isolate. It's really, really difficult to give a timescale, but that is what everybody wants to know. How quickly can I be in?
That was a good politician's answer, right there, Jennifer.
I had a big long list of questions, including 2 from our chief exec, but you've answered them all, Laura. So I have no questions left. So well done.
I've got a question.
There was a lot to deal with there. I think there was a fair few topics.
Yeah, Taj has got a question, I think. Do you want to quickly chip in with it, Taj?
Yeah. To any of the speakers, really. I know Adam talked about delay clauses. Are we seeing any sort of average time span to those delay clauses, or is it a sort of a moving thing with everything that's going on?
From a residential point of view, if we put the clause in, we do agree sort of an extended completion date, so a long stop date, so there is a final date in there. Otherwise, you could just be waiting forever to actually move, so that date does have to be agreed.
What was the date on that one, Jen? We had that matter, didn't we? And there was what was the long stop date that was being proposed on that one?
Well, that one, because we're buying, but the seller who's buying onwards was buying a new build property, so that wasn't going to be ready until September. So what they wanted to do was put another 2 months on, so that the end date was 5 months from exchange of contracts.
Yeah.
But the original 3 month delay was due to the new build property not actually being ready. So I would say normally the extended date would probably be around 3 months, but they're all different.
I think I'd probably echo that, Taj. I had a transaction that exchanged contracts just as lockdown was coming in, and we didn't put any delay clauses in there, but we agreed a completion date at the end of August. So I think a lot of people I think we'll probably say this around 3 months, and end of August, start of September. That seems to be the sort of time Laura mentioned before about the extension on the moratorium, things like that. It seems to be tying into the start of September. As I say, I think it'll be very much subject to whether or not we see a second wave and an additional lockdown. But otherwise, I would say end of August would be the sort of time people are looking at.
Okay, great. Thanks, Adam. Thanks, Taj. If there's no final questions, I'll wrap it up. Thank you once again to Forbes. Thank you to Adam, Laura, and Jennifer. And have a great week, everybody. Enjoy the sunshine.
Thank you.
Thank you.
Thank you.
Bye, everyone. Thank you.
Bye. Bye.